Welcome to this presentation relating to Chapter 3. This is the second lecture that we have on Chapter 3, and we'll be starting on slide 16. Just a reminder, we're on Chapter 3, which covers ethics and professional responsibility. In the first lecture, we covered slides 1 through 16, and we're going to resume on slide 16. We are, for the rest of the lecture, going to talk about the NALA's 10 canons of professional responsibility, the Texas Disciplinary Rules of Professional Conduct, and also the Texas criminal laws regarding the unauthorized practice of law. So let's first of all talk about that first category, NALA's Code of Ethics and Professional Responsibility. Well, first of all, it's voluntary. Nobody on planet Earth has to follow those rules. Paralegals who become a member of NALA, of course, are supposed to follow those rules, but the worst thing that NALA can do if somebody doesn't follow those rules is kick that person out of its organization. But that person can still call himself or herself a paralegal and can still practice as a paralegal. So in that sense, it's voluntary. It's voluntary, but as we talked before, paralegals are indirectly regulated by the rules of the State Bar Association. And honestly, NALA's rules are completely in line with what state bar associations require, including Texas's State Bar Association. So the concepts we see in NALA are not voluntary. They are required for attorneys because they're required by they're required for paralegals for the same reason they're required for attorneys. There are 10 canons, and we'll go through all 10 of them in this lecture. The first 5, and we will do the first 5 first, are the paralegal-specific ones. And then the second half, the second 5, are going to relate to all legal professionals, including attorneys and other professionals who work in the legal environment, legal secretaries and other individuals. This page in the textbook is probably wrong. This is from an earlier edition. You'll be able to find this information, though, in Chapter 3 of the textbook, where you'll see the 10 canons listed. So let's talk about the second tool. So here we've now talked about this first analytical tool right here. Now we're going to go talk about the Texas Disciplinary Rules of Professional Conduct. We talked about them in some length in Lecture 1, but just a little refresher. Again, of course, these Texas Disciplinary Rules are the rules of the Texas Bar Association. So it only applies to members of the Bar Association specifically. And so this would apply to attorneys who practice in Texas and are members of the bar. However, even though those are the only people who are directly regulated by the Texas Disciplinary Rules of Professional Conduct, because the paralegal has to be supervised by an attorney who's a member of the bar, paralegals are indirectly regulated because if a paralegal violates one of these rules, he or she is jeopardizing the license of the attorney with whom he or she works, which of course ultimately jeopardizes the paralegal's career. I have a link to the actual rules on Blackboard. Let's go there for a second so I can show you. You are not at all responsible for reading the rules or anything like that, but I always like to show as much as I can about where we find these things. So we're going to go to web links. And then near the bottom, we will find the Texas Disciplinary Rules of Professional Conduct. Well, actually, this looks more like a reference to a helpline. So let me see if I can actually find the rules. Texas Disciplinary Rules. Professional Conduct. Okay, so I'm going to click on this. If you'd like to send me an email to remind me to update Blackboard, I would appreciate that. So you can see here are all the rules. This document is 124 pages long. Let's just kind of scan quickly through here. And I will at various points cover specific aspects of the rules, or we'll probably pull them up and look at it in more detail. Okay, so now we've talked about NALA's code and the Texas Disciplinary Rules of Professional Conduct. Now we're ready for the criminal law sanctions. The unauthorized practice of law. First thing to keep in mind is all states have a similar statute. There's going to be a question on a future test on that issue. So this is not something that's quirky with Texas, it's universal. Just like we don't want people pretending to be doctors or nurses, we don't want people pretending to be attorneys who are not. Depending upon the way that it is pled, it can be prosecuted as a misdemeanor offense or a felony offense. Non-attorneys can obviously violate the law, but it is easy for attorneys to violate the law, and my guess is that attorneys are the people who most commonly violate this law and are probably the people who are most likely to be prosecuted under the law, because if I am licensed in Oklahoma, but I cross the Red River and come to Texas and attempt to practice law, I'm in violation of law. It is true that I have the requisite legal knowledge most likely to be able to be admitted to practice in Texas, but I haven't followed the steps that I need to take to be admitted in Texas. So that's probably the most common way that we see unauthorized practice of law situations. But certainly there are non-attorneys who attempt to practice law, or paralegals who cross that line and either inadvertently or intentionally start practicing law. The criminal statutes require that the person who's being prosecuted intended to benefit financially from giving or engaging in unauthorized practice of law. We'll talk, though, as going forward, examples that really doesn't, it's a requirement, but doesn't really help paralegals avoid culpability under the statute. It doesn't actually require, for example, that the person actually receive any financial benefit, or that the financial benefit be especially significant. Moreover, simply because the criminal statute requires that the person receive financial benefit, that doesn't mean that it's still not an ethical lapse that may not be criminal to engage in unauthorized practice of law even without a financial benefit. Another thing to notice that in Texas, and my guess is other jurisdictions, is a very broad statute of how they define the practice of law. We'll talk more about that when we get to the statute. So we've gone through the four methodologies that we're going to do for the rest of the class. We've kind of described what those documents are. Here, let's do a little true and false. Only attorneys can be guilty of unauthorized practice of law. That's false. Attorneys can be guilty of it, but so can non-attorneys. Of course, the reverse statement is also true. Attorneys can never be guilty of unauthorized practice of law. That is also false. Attorneys can be. A couple things I'd like to point out. We have the word only. Only, even though we don't ordinarily think of it as a negative word, it is a limiting word. Only attorneys can be guilty. When you see words like that, that makes the true-false statement more difficult to be true. Here we have the word never. Again, it's another limiting word. Attorneys can never be guilty of unauthorized practice of law. When you see a word like never, always, or ever, keep in mind that if there's just one situation that doesn't comport with that requirement, the statement is false. Even if it's true 99% of the time, when it's false 1% of the time, it's a false statement if it were offered on a test. The way I like to think about it is, imagine that I make a nice pot of soup, and I have vegetables and carrots and potatoes and sausage and rice and all kinds of yummy stuff in the soup. But I put just 1% of arsenic in the soup. It's 99% delicious, healthful, wonderful food. But that 1%, if you know that that 1% is arsenic, you're not going to eat it, nor should you eat it, because 1% falsity poisons the whole dish, and it makes what would have otherwise been a true question a false question. The other unauthorized practice of law is a civil matter. Now, you can look upon this as this is a poorly worded question. I'm going to call it false because we use the term unauthorized practice of law to describe a criminal event. The same behavior that under criminal law is called the unauthorized practice of law would be an ethical breach under the Texas Disciplinary Rules of Professional Conduct. But since we're using this term, this word really should be criminal. And so I'm going to call it false, although, again, I don't think it was probably the best worded sentence or best worded true-false question. I promise you, when we get to tests, they'll be better. Okay, so now we're going to go through the things that paralegals must not do. And we're going to talk about canons 1 and 2 of NALA. Here we have canon 1 on top, and we have canon 2 on bottom. I've highlighted a few keywords or bolded them. They aren't bolded in the original, but this kind of gives you a sense as to what I think the most important parts are. A paralegal must not perform any of the duties that attorneys only may perform, nor take any actions that attorney may not take. So basically, a paralegal can't do those attorney-only things. So this has to do directly with the unauthorized practice of law and that prohibition. Let's look at canon 2. A paralegal may perform any task which is properly delegated and supervised by an attorney, as long as the attorney is ultimately responsible to the client, maintains a direct relationship with the client, and assumes professional responsibility for the work product. So we have here that specifically delegated substantive legal work stuff. So we have here what paralegals can't do, and then what paralegals can do. And again, this is the meat. This is a good explanation about what paralegals are going to be doing. So this is what NALA says about these two topics. Let's look at what the Texas disciplinary rules say. And we're going to look at the attorney's duty to supervise. And as we've talked about before, the attorney always has the duty to supervise any non-lawyers who work in his or her office. And the rule number, which you don't have to know the rule, but I'm just putting here as reference, is 5.03. So let's just go to 5.03. Oh, I went a little too far. Okay, here is 5.03. I also have put it on the PowerPoint. And it's just verbatim recitation of those facts. With respect to a non-lawyer employed or retained or associated with an attorney, the lawyer is supposed to directly supervise. And the lawyer can be disciplined by the state bar if that person that the attorney is supposed to be supervising violates any of these rules. So again, the attorney has skin in the game. He can't just wash his hands and say, well, I didn't do it. It was my assistant who I was supposed to be supervising, but it wasn't. No, the state bar is not going to buy that. Let's look at some activities that, or figure out whether an activity can be done only by an attorney or can be done by an attorney and a paralegal. Appear in court. This is an attorney-only function. So I'm going to say attorney-only here. Draft a will. Well, let me pause here and say the problem with this is the word appear. Appear has a very specific meaning in the law. It means to appear on the record. It means to represent one of the parties. Paralegals routinely are in court. In fact, I would say that in many law offices, paralegals spend more time in court than most attorneys. But they aren't on the record in the court. And so therefore, while they're present and doing important work and billing their time, they aren't making an appearance in court. And so therefore, this is an attorney-only function. The next one, we have the word draft. This is also an important word relationship. This is not an attorney-only function. So I'm going to say not NAO, because drafting the will is a common function for a paralegal to do. As long as the paralegal shows the draft will to the attorney before it goes out to the client, that's a perfectly appropriate thing for the paralegal to do, and would be a routine thing for a paralegal to do in an estate planning practice. Sign pleadings. Again, the key word here is the word sign. Paralegals routinely prepare pleadings, draft pleadings, but a paralegal cannot sign the pleadings. We'll talk about the importance of signing pleadings, or what the legal significance of signing the pleadings is in a later course, but just know for now that the signature isn't just saying, I wrote this. You are making certain substantive statements about the document by signing it. You are signing it as a member of that particular court, be it the State Bar Association or the federal court or some other state bar. You are saying, I vouch for this document. I've done research and I know this is a good document. And so if somebody who isn't a member of that particular court signs the document, the court doesn't have the ability to discipline because the person who signed it is not a member of that court. It isn't bound by those ethical rules. So signing it is an attorney-only function. Now there is an exception here though. Paralegals and anybody else can sign a pleading if he or she is the party who the pleading is about. So a plaintiff can sign his or her own petition or complaint. A defendant can sign his or her own answer because no one is required to hire an attorney. A person can be what's called pro se or pro per, meaning he represents himself in the matter. Depose a witness. This is also an attorney-only function. While paralegals are routinely at depositions where witnesses are deposed and have very important roles, they are not the person who's asking the question on the record. The reason that attorney only can depose is that counts as a court appearance because the witness is under oath and that testimony can be brought into court. And so only the attorney can ask the questions. So what does a paralegal do? Well, a paralegal can first prepare the witness to be deposed, practice the likely deposition questions. An attorney can prepare draft questions for the deposition. The attorney obviously ultimately has the decision about which questions to ask, but many times the attorney may ask the paralegal to do this, and the attorney may simply be reading the questions aloud. The paralegal can arrange all the specifics about the deposition. She can schedule the court reporter, reserve the room, schedule it working with opposing counsel. The paralegal can arrange the exhibits that may be used in the deposition, have them organized with lots of copies for the various participants, and also keep a record of what exhibits were put into evidence to make sure that everything in fact got into evidence. Paralegals can listen to the testimony, can be listening for inconsistencies in the testimony compared to other witnesses or compared to what this witness has said in the past, can also suggest follow-up questions for the attorney to ask. In addition, the paralegal is in a position to evaluate the body language and demeanor of the witness. The attorney oftentimes is so focused on asking the questions and making sure that the record is clean in terms of how he's asked the questions that he or she may not have had as much opportunity to notice the demeanor of the witness. And obviously the jury is going to care very much about how this witness comes across. Is he credible? Is he likable? Is he reasonable? All those ideas that the paralegal may be in a position to evaluate. After the deposition is over, the paralegal oftentimes will sit with the witness and go over the deposition transcript to make sure there's not any inaccuracies. And finally, the paralegal, at least historically, was responsible for summarizing the deposition, for basically doing kind of a book report or a condensed version of the deposition, which could be used to prepare for a trial or can be used to prepare for dispositive motions. So again, the paralegal has really important roles with respect to depositions, but doesn't literally ask the question. So therefore, this is an attorney-only function. Interview a client. This is not an attorney-only function. It is true that in certain practices, the attorney may choose to be the one who interviews the clients, but in many other practices, it's the paralegal who has that role, that primary role. Conduct legal research. This is not an attorney-only function. Now, I want to pause here and talk about legal research because this sometimes throws people. Legal research is, by definition, the development of legal advice. You are looking at the cases and you're drawing legal conclusions. You're saying this case is closer to our fact pattern, our client's fact pattern, than this case. Or this case is a better statement of the law than this case. It is inherently the development of legal opinion. So why isn't that the unauthorized practice of law? Well, it isn't because the paralegal is going to share that information with the attorney directly. The paralegal is not going to give it directly to the court or opposing counsel or to the client. As long as the paralegal is sending that information directly to the attorney, the paralegal is doing exactly what he or she is supposed to do. There's no unauthorized practice of law in that situation. Similarly with drafting the will. Drafting the will is clearly an attorney or the practice of law. As long as the paralegal is preparing it for the attorney to review, it's perfectly okay. There will be a question on the test covering this concept, so be sure you understand that when the paralegal is showing the document to the attorney for his or her approval, then that's perfectly appropriate. Agree to take on a client. This is an attorney-only function. The attorney-client privilege, of course, the attorney-client relationship requires, guess what? An attorney and a client. No big surprise there. And only the attorney and the client can establish the relationship. Because the paralegal is neither the attorney nor the client, the paralegal cannot establish the relationship. Having said that, it's very common, especially in plaintiff's law firms, for a paralegal to function as an intake paralegal. Oftentimes, this is a paralegal's first job in a law firm. In that position, the paralegal is given specific guidance for how to interview potential clients, and usually a questionnaire to complete. And what the paralegal will do is interview the potential client, because of course in a plaintiff's law firm, the fee arrangement is likely to be a contingency fee arrangement. So what the attorney is doing when he or she accepts the case is he or she is essentially exchanging his or her services for a cut in whatever that client might gain from the lawsuit. Well, if the client doesn't have a very good claim, then the attorney isn't going to want to take the case, because, 50%, or actually not 50%, but say 30% of nothing is, nothing. And so it wouldn't be very sensible to take on a case like that. So the attorney needs to sort through the case, the potential clients, and find the cases where there is a likelihood of success. And so that's what the paralegal is doing. So the paralegal will gather the facts, and very likely he or she will have criteria to use to make a recommendation to the law firm about whether this is a case that ought to be accepted or not. Oftentimes, the paralegal will be looking for these three things. Is there clear liability on the part of someone other than our client? If it's like a car accident case, based upon the information that you have, does it appear that our potential client was in the right and the other guy was in the wrong? You need to have that in order to have a successful case. You also need to have significant damages. If there was a car accident, but our client's car just had a little bit of a fender bender, even if it's very clear it's the other guy's fault, maybe the total damages are only $5,000 or $10,000. Hardly worth the expense of taking on the case for such a small recovery potential. In addition, you're going to want to see, this is the third element, is there a deep pocket? Is there somebody out there who is potentially responsible for the behavior of the defendant, who can be made to pay, who has the money to pay? If it's a car accident case, we're typically looking for the insurance company. If the person was uninsured, probably that person lacks the resources. So there might be very significant damages, and it might be obvious that person was highly responsible for the accident. But under those circumstances, it does not at all follow that the plaintiff's law firm is going to want to take the case, because you can't get blood out of a turnip. You can't get money out of somebody who doesn't have money. So in that situation, the intake paralegal is going to look for those three characteristics, and then based upon the criteria the law firm has, make a recommendation to the law firm about, do we take this case on, do we not? So no, it's not the paralegal's decision, but the paralegal is oftentimes very involved in that process. Negotiate a fee arrangement. This is, again, an attorney-only function, because, again, the fee arrangement is an essential part of the attorney-client relationship. And so the paralegal can't be the one who negotiates that. Having said that, it's pretty common in law departments for there to be set kind of fee arrangements that law firm uses in all or most cases. And so under those circumstances, the paralegal might well explain to the client or the potential client, this is what the likely fee arrangement is going to be, and explain how it works, even though the paralegal cannot negotiate it or change those terms. Give legal advice. Again, this is an attorney-only function because of the word give. If it were developed legal advice that is discussed with the attorney, that could be a paralegal. So it might be that this legal advice that the attorney is giving to the client is actually legal advice appropriately developed by the paralegal that is shared with the attorney, and then the attorney who agrees with it shares it with the client. Investigate the facts. This is not exclusively an attorney-only function. Paralegals routinely investigate facts. Of course, all of these things attorneys also do. So when I say it's not an attorney-only function, attorneys routinely do these things as well. Recommend a settlement amount. This is an attorney-only function. When I say recommend, I'm assuming it means recommend to the client. I'm going to add that, to the client. a settlement amount. This is an attorney-only function because, again, this is giving legal advice. When you recommend a certain amount for settlement, you have inherently decided, well, this case is worth this much, not more, not less. And that requires that you have an understanding about the strengths and weaknesses of the case from a legal perspective. Now, having said it's an attorney-only function, if you were making a recommendation to the attorney for what should be conveyed to the client, then it's not an attorney-only function. A very routine thing for a paralegal to do would be to research jury verdicts in the area to decide kind of what would be a good number for the client to consider in terms of settlement potential. But the paralegal is going to develop that research and then give it to the attorney. Then the attorney will decide how and when and where to convey that to the client. Correspond with opposing counsel. This is not an attorney-only function. It's pretty common for the paralegal to send out correspondence to the court or to opposing counsel. Now, there are plenty of attorneys who like things going out to the attorneys to be under the attorney's signature. So I'm not saying that just because it's okay for the paralegal to send it out that it follows that that will be the way your office does things. But it's certainly not an ethical breach for the paralegal to send out letters to opposing counsel. So, true or false? Is this attorney-only function, giving legal advice to the client? Well, yes, that would be true. Giving legal advice to the attorney who represents the client. Now, this is not an attorney-only function. Again, this is completely appropriate. You will see something like this on the test, so remember this. Entering into attorney-client relationship. This is an attorney-only function, so yes. Now, sometimes people get confused on this, and there will be a test question on this too. They will say, but this isn't giving legal advice, right? That's what attorneys can do that paralegals can't. Well, you're right. The main thing that attorneys can do that paralegals can is give legal advice. But there's also a few other things, and this is one of those other things. Also, making a court appearance is another one of these things that isn't legal advice, but is something only attorneys can do. Okay, so now we've gone, let me go do a little refresher, go back to, we've done canons 1 and 2 of null, and now we're up to canon 3. And so we have 3 parts for canon 3. A paralegal must not engage in, encourage, or contribute to any act which would constitute the unauthorized practice of law. A paralegal must not establish attorney-client relationships, set fees, give legal opinions or advice, or represent a client before a court or agency unless so authorized by that court or agency. And a paralegal must not engage in conduct or take any action which would assist or involve the attorney in a violation of professional ethics or to give the appearance of professional impropriety. And we also have canon 4. A paralegal must use discretion and professional judgment commensurate with the knowledge and experience, but must not render independent legal judgment in place of an attorney. The services of an attorney are essential to the public interest whenever such judgment is required. Okay, so let's look at a couple of examples to see whether these are situations in which good professional judgment exists. Now, before we get started, these are hokey. I know they're hokey. The facts are, it's just not possible to give a genuinely challenging question that's like 2 or 3 sentences long. So forgive me in advance for somewhat silly questions here. So we have paralegal. Paralegal is researching Texas contract law. The client resides in Oklahoma City, and the contract is between him and an Enid, Oklahoma resident, entered into in Tulsa, Oklahoma. Is the paralegal exercising good professional judgment? Why, no. He should have researched Oklahoma contract law. Okay, let's go to the next one. Paralegal is drafting a complaint to be filed in court that, I guess I have my genders mixed up here, is filed in a court that he usually does not deal with. He checks the local rules to make sure the complaint's format is appropriate. Yes, he is very good professional judgment. Just a pause here to talk about local rules. Virtually all courts have local rules. There's going to be, if in the Texas system, we'll have Texas rules of civil procedure, Texas rules of criminal procedure. In the federal system, you'll have federal rules of civil procedure and federal rules of criminal procedure. Those rules apply throughout those 2 systems. But each court will have its own set of local rules that are more specific to its particular court. They're not going to contradict the overall rules, but they will provide more specific information. Let me just look at the local rules for the Northern District of Texas. This would be a federal court. And here we have the local rules right here. So I'm going to expand here. And we have the local rules for civil matters, the local rules for criminal matters, the local rules for the bankruptcy court. We're just going to look under the civil rules. And again, here are the rules. The things that are specific to the Northern District. So in other words, the Eastern District of Texas or the Southern District of Texas might have very different rules here. This is how to find them. So you always have to check those when you're practicing in court. Paralegal is drafting a will for a single client. She knows that community property can be tricky, so she spends 7 hours researching the law in this area. Well, of course, community property only applies when a person is married, and we know that this person is single. So no, this paralegal made some foolish decisions. A single client won't be interested in paying for those 7 hours of research. So that was a poor decision on the part of the paralegal. Okay, so now we're looking at we've looked at Canon 4. Now we're going to look at the related Texas Disciplinary Rules of Professional Conduct. A lawyer shall not practice law in a jurisdiction where doing so violates the regulations of the professional in that jurisdiction. Going back here, rule number 3. The attorney shouldn't engage in unauthorized practice of law, and neither should the paralegal. Here we go. And a lawyer shall not assist a person who is not a member of the bar in the performance of activity that constitutes the unauthorized practice of law. So if the lawyer is supervising a paralegal who's doing this, he has violated his professional responsibilities as well. So let's look a little bit more about the the unauthorized practice of law requirements. Okay, which stands for where UPL is the typical way people just discuss these. So we're going to look at statutes, but of course, statutes can be interpreted by courts. So we also have the common law. We look at court opinions too to see how particular terms in the statute have been defined over time. So generally, what are the things that are prohibited? Well, of course, establishing the attorney-client relationship, setting legal fees, giving legal advice, and representing a client before a court when the court has not authorized it. And of course, in any way, facilitating someone else doing that. Those are ways that you get into the unauthorized practice of law. Let's look at some things, though, that might not, or just a little more specificity. Generally speaking, and this is true in Texas, an attorney cannot fee split with a non-attorney. This is perhaps not obvious when you consider this issue, the issue of the unauthorized practice of law. Imagine, for example, that Bob is the paralegal and Mary is the attorney. Mary's a plaintiff's attorney, and she wants to motivate Bob to really work very diligently on some cases. So she says to Bob, if we're successful in this lawsuit, I will give you 10% of whatever I recover as my contingency fee. Bob thinks, wow, that motivates me to work harder. And so, yes, I'm excited. As a result, Bob does work hard, and Mary works hard, and they are successful in the lawsuit. And Mary persuades the jury to award her client $3 million. Mary gets a third of that, so she gets $1 million, and Bob is entitled to 10% of that, or $100,000. It looks like it was a good situation all the way around. The client got money, Mary got money, Bob got money, everybody's happy. Well, everybody might be happy except for the Texas Bar Association, because Mary created a contract between herself and Bob, and that contract was unlawful because it involved fee splitting. Mary, the attorney, cannot engage in a contract in which part of her remuneration from her client, she has a contractual obligation to share with someone else. So let me contrast what Mary did, which is unlawful, or unethical with some other things Mary could have done, which would have been just fine. Mary could have agreed to just pay Bob his wages. She could have paid him on an hourly basis. She could have paid him on a salaried basis. She could pay Bob, $500,000 a year if she wants to. There's no unethical aspect to paying Bob a lot of money. It was the fact that Bob's money was tied to how well the case went forward. That was the problem, not the salary that Bob was earning. Another thing Mary could have done, and this is quite common in plaintiff's law firms, is that Mary could, after the case was resolved and she got her $1 million, she could have given discretionary bonuses to her employees. She could have given Bob $100,000. She could have given Bob, $900,000. She could give Bob whatever she wants at that time. Because she has no contractual obligation to do so, it would not be considered fee splitting. And of course, plaintiffs' law firms that routinely share the wealth, give some of their money, which of course is a smart plan for them to make because it keeps their employees happy. Over time, there may appear to be this pattern. It may be that whenever there's a verdict over, $1 million, that the lead paralegal in the case gets 5 or 10% of whatever the verdict is. It may be so common that the plaintiff, the paralegal is kind of planning for it, seeing it as a given, as a for sure thing. And it may work out that that's exactly what happens. But when there is no actual contract for that, and it's just a discretionary decision that the law firm makes each time, even if it's very, very consistent, it's still not counted as fee splitting. So we may be engaging in hair splitting at some point in time, but in theory, that's how the law works. You may be wondering, okay, you explained what the rule is, but why? Why do we have this rule? The reason for that is that even though paralegals are indirectly regulated, because they're not directly regulated, there is that opportunity for them to do some things that could violate the rules. Let's go back to the scenario where Mary did offer Bob 10% of whatever her law firm recovered as a result of the representation of the client. Well, let's say Bob looked at that and goes, wow, okay, this is highly motivating for me now. There's some pieces of evidence that I'm supposed to give up in discovery, but now I don't want to give it up in discovery because they're not good for our client. And so he might destroy some evidence. He might tamper with some witnesses. He might do all kinds of unethical things. But guess what? He can't be disbarred by the Bar Association, right? Mary can be disbarred, it's true, but because she was supposed to be supervising Bob. But the idea is that Bob could have an incentive because he's legally entitled to this result that could cause him to misbehave, and the Bar Association doesn't have the direct ability to control him. So that's the reason why fee splitting is not allowed. There has been some discussion in the legal community about changing this rule. At this time, it hasn't been changed, though. We're already discussed the idea about giving advice. A non-attorney can only convey an attorney's advice, not his or her own. Sometimes a paralegal may develop legal advice, talk to the attorney. The attorney says, yes, that's exactly what we need to tell the client. Now go tell the client. That's perfectly fine. It is fine for the words of the advice to actually come out of the paralegal's mouth, although the paralegal ought to make it clear to the client that these are the attorney's words. And it would not be appropriate for the paralegal to say, yeah, I did all the research, I told the attorney that's what we ought to do, and the attorney said yes, so now I'm telling you. That wouldn't be the best in terms of client relations. Now, of course, the bill will be presented to the client, and so the client will likely see how much time the paralegal spent on it versus the attorney, but it's probably not good client relations to it could be confusing to the client to present it in that way. But that's not an uncommon scenario to have happen. The paralegal may spend several hours developing the advice, the attorney may just spend a few minutes reviewing the advice, and then the paralegal may communicate the advice to the client. All that is perfectly fine as long as you have that middle step where the attorney is involved. Again, generally speaking, paralegals cannot represent clients in court, unless there's a few agencies that do allow. One is in certain immigration hearings, non-attorneys can represent, and in Social Security disability hearings, non-attorneys can represent. And there's other agencies out there. Those are the two that I'm familiar with. It's a very, very good idea for a paralegal to disclose his or her status as a paralegal at the beginning of any discussion with a client or potential client. This helps the client understand the paralegal's role versus the attorney's role. It can also be helpful for the paralegal in terms of managing the relationship and the expectation. Most clients are not legally sophisticated. They don't know the difference between a paralegal and an attorney, so simply saying the terms isn't really going to be adequate explanation for that client. So you're going to want to talk about what your role is, what your duties are compared to the attorney's. And so when the client starts saying, well, I need to answer this question, that's when you can say, well, that's not my role, that's the attorney's role. You need to talk to him about that. It's good to have that initial conversation during maybe the first meeting, but very likely you're going to want to refresh the recollection of the client from time to time, especially when he or she seems to be expecting you to do things that aren't appropriate for you to do. It's a good idea to include your paralegal status in all written communications. Typically, it's going to be in your signature block if it's an email, and likely you'll have one signature block you use all the time, so you don't have to remember to keep on putting it in. And when you send out letters, you're going to have that as underneath your name. You know, it'll be something like, just type something up here. Very truly yours, Cynthia Groover, paralegal. In fact, if it is on law firm letterhead, you need to have underneath, or sometimes on the same line as your name, some description that makes it clear that you are not a licensed attorney. Because the assumption is, if it's on law firm letterhead and the name of the person who is signing the letter is in fact a licensed attorney. So you want to have that on all written and oral communications. Now, of course, if you've talked with somebody more than once, especially commonly, and they know who you are, you don't have to keep on reintroducing yourself. That would be silly. But if you think there's any chance that they don't know who you are, that they've confused you for an attorney, it's a good idea to remind them who you are. Now, sometimes people think, well, if I disclose that I'm a paralegal, that somehow solves the problem of the unauthorized practice of law. It doesn't. It's a very good fact. If a district attorney were trying to decide whether to prosecute someone or not for the unauthorized practice of law, the fact that person disclosed his or her status as a paralegal is one that certainly the attorney could seriously consider. Let's, though, think about an example. Let's say that I'm a paralegal and you're my good friend. You know I'm a paralegal. You know I didn't go to law school, but I happen to practice in a family law practice, and you don't have any legal training, and you are going through a divorce, and you want to pick my brain and find out some information. You're planning on representing yourself in the divorce, but you sure think it'd be helpful to get some information. And so you say to me, hey, let's go grab some dinner, my treat, and we can sit and talk about my divorce, and we can discuss some strategy, and I'm just not quite sure about how I should proceed on some specific issues that have come up in the case. We go to lunch, we have lunch, you buy, or dinner, or whatever, you buy my meal, and over the course of the meal you ask me several questions. What strategically should I do here? Should I agree to this amount of settlement or that amount of settlement? And I give you advice, and specific advice about your circumstances. Even though you knew I was a paralegal, I have still engaged in unauthorized practice of law. For one thing, I got some legal benefit, some financial benefit. You bought my dinner, but apart from that, I gave you advice that is specific to your circumstances, so therefore it qualifies as legal advice. So the disclosure of paralegal status is a good idea, but it's not some magic pixie dust that changes the unauthorized practice of law into something that's okay. Let's talk about the issue of freelance and independent paralegals. Freelance paralegals are, I wouldn't say they're common, but they certainly are out there, and they're a perfectly appropriate career path for a paralegal. In this situation, a paralegal is an entrepreneur. He or she markets his or her practice to law firms and law departments around town. In this situation, he or she is not marketing himself or herself directly to clients, but to attorneys. And so the freelance paralegal might work for this law firm today and another law firm tomorrow. That's perfectly appropriate and is fine, assuming that the paralegal is adequately supervised by an attorney. Legal technicians is what the textbook calls this, but probably a better term for it would be independent paralegals. These are paralegals who provide legal services directly to the public without the involvement of attorneys. This is highly dangerous. I don't think that this is possible to do ethically in the state of Texas, and I think that it would expose that paralegal to criminal charges potentially. So I do not recommend this. Freelance paralegalism, great. Independent paralegals, not so great. Highly discourage you from considering that particular path. Okay, let's look at two scenarios in which a paralegal is presented with some instructions from the attorney and see what the paralegal ought to do under these circumstances. Okay, so we have John is a paralegal. His attorney, we'll say his attorney is Bob. Bob asks John to review a file and advise the client whether a settlement offer should be accepted. Now, Bob has told John to do this, so is it okay for John to so do that? No, because you can see that there is no intermediate step where John's supposed to go back to Bob. Reviewing the file is a perfectly normal thing for John to do, and once John reviews the file and comes up with the advice that he'd like to give to the client, if he had been instructed to go back to Bob, and then once he and Bob had talked and Bob approved the advice to then take it to the client, everything would be copacetic. That'd be fine. That would not be the unauthorized practice of law. But we're missing that middle step. There is no talk to Bob. Oops. So as a result, no, cannot do this. As written. Now we have paralegal Jamal. His attorney is, we'll say, Susan. Okay, so Susan has given Jamal explicit and detailed guidelines for how to prepare non-contested divorce papers. Susan is on vacation and the client insists on filing right now. Because the instructions are so detailed, can Jamal follow them to the letter and have the client sign the divorce petition? No. Again, Jamal can prepare the papers according to Susan's directions, email it, or fax it, or whatever to Susan wherever she might be, or to whatever attorney Susan has delegated, who Jamal can contact in Susan's absence, get approval, and then Jamal can present it to the client. But it doesn't really matter how explicit and detailed the guidance are. An attorney has to review it because there are just too many variables in that situation, too many things. Even though they're detailed and explicit, an attorney's instructions aren't going to cover every single piece of information that could affect the advice that is given. So both of these are no. And they're no because after the advice is developed, there needs to be that middle step where the paralegal goes to the attorney. Here is our Texas statute on the unauthorized practice of law. And again, the highlighted parts or the bolded parts are things that I have added. They're not bolded in the actual statute. A person commits an offense if, with intent to obtain an economic benefit, so this is a financial requirement, for himself or herself, the person contracts with any person to represent that person with regard to personal causes of action for property damages or personal injury. Also, if the person advises any person as to the person's rights and the advisability of making claims for personal injuries or property damages. Also, if the person advises any person as to whether or not to accept an offered sum of money in settlement for claims for personal injuries and property damages. All these are really tied to personal injury lawsuits, but that's not the only way you can run afoul of an unauthorized practice of law claim. Let's go forward. The term practice of law means the preparation of a pleading or any document incident to an action or special proceeding, or the management of the action or proceeding on behalf of a client before a judge in court, as well as a service rendered out of court, including the giving advice or the rendering of any service requiring the use of legal skill or knowledge, such as preparing a will, contract, or other instrument, the legal effect of which under the facts and conclusions involved must be clearly determined. And then finally, the definition section is not exclusive. It doesn't cover everything. So that's this is where I had the statement that the definition of practice of law is very broad. You have to be careful not to cross those lines. Okay, so let's look at 3 instances to see whether this person crossed the lines. Paralegal gives a client her personal recommendation regarding a settlement of the case. So let's say the client wanted to settle his lawsuit for $50,000. The attorney said he ought to settle for $10,000. Paralegal says, "Oh no, the attorney is saying $10,000, but I think this case is worth at least $30,000." Okay. So this is the question. While she acted unethically, she did not engage in unauthorized practice of law because she did not intend to receive a financial benefit. True or false? Well, actually the answer here is false. You might say, well, what financial benefit did she get? Well, I'm guessing she was expecting a paycheck from her employer, from the law firm. And certainly the client is paying the law firm for money. Now, it is true the client is not directly paying the paralegal money. The paralegal is drawing a salary or being paid on an hourly basis. So there isn't a direct connection between the number of hours the paralegal works on the client's case and the amount of money the paralegal earns, but there's an indirect relationship. So there is a financial benefit, and therefore paralegal acted unethically by giving her personal opinion to the client. A paralegal answers the client's questions about the steps involved in the lawsuit, but makes no statements that relate to the client's own claims. Does giving this advice violate the law? False. Or I'll say no, I guess. And this is an example where you have to have a lot of legal knowledge to do this, but it doesn't count as legal advice because it's not personalized to the circumstances of the client. So explain the legal process that exists generically, or that applies to everyone is not legal advice. It's only when you start saying, and because of this generic rule, this is how we ought to proceed in your case. That's when you get to legal advice. As long as the client is fully aware that the paralegal is not a licensed attorney, the paralegal cannot be guilty of unauthorized practice of law. And that is false. We talked before, it's a good fact for the paralegal, but it doesn't somehow inoculate him or her against an unauthorized practice of law claim. Okay, so we've gone through the first 5 canons. Let's go forward, and in our next broadcast, we will cover the next 5 canons. Or I guess, well, actually, the next 6 canons. Thank you for your attention, and we will end at this time.